watching part 16 of this series, The Assault on Our Constitution, with special guest and best-selling author Don Brown.
Well, welcome. I'm here, Rick Joyner, with Don Brown. Again, we're still hammering out solving the problems of the world and our country, especially in relation to our Constitution. And we have the subject today that is the most, I think, the most important of all that we've covered. And every one we've covered has been critical, in my opinion, but this is an imminent threat to our republic. And it was foreseen as that. Thomas Jefferson especially wrote extensively on this subject, judicial tyranny. Jefferson and others considered this probably the greatest threat to our republic. This could bring us down the fastest. It could shatter everything, could unravel the Constitution. He saw it as the main thing, disconnecting us from our Constitution. And so I think it is a very critical subject. And, you know, Don has done such great research on all these subjects. And thank you for also, I want to say right now, for all of you who are passing these around, telling your friends about it. Thank you for the reviews we've gotten, the comments and all. Appreciate your questions. We will run a little banner on the screen if you want to send in questions or comments. We really appreciate those. Any challenges, we appreciate those too, because those help us to clarify some things. But Don, you know, right. We've talked together a lot about this, but as always, you got some amazing PowerPoint presentation with this. And
well, Rick, you know, I know this is something that's a passion of yours and is of mine too, because, you know, our Constitution was put together and designed as a device that limits the power of government. Mm-hmm. And we talked about we are a constitutional republic and not a democracy, and there are three elements of a constitutional republic. Number one, there are checks and balances. Number two, a constitutional republic is governed by the rule of law, not the rule of man. We were together last time. You talked about at the end of Judges, it said that everyone did what was right in his own eyes, and that's really a definition of democracy, people doing what they want to do. But a constitutional republic has checks and balances to prevent too much power from anyone, especially in the government. And then the rule of law is more important than the rule of man. The rule of man is not important, and that rule of law must be based upon Judeo-Christian principles. And when we talk about the issue of judicial tyranny, when we say that a constitutional republic first has checks and balances, well, one of the greatest checks and balances that we've already talked about is separation of powers. Mm-hmm. I've used the example of my grandmama's pecan pie when she cuts the pie up in 3 slices. Actually, our founders did that with the Constitution, cutting the government up into 3 slices. The executive, first actually the Congress, and then the executive and the courts. But the slices of those pies are not equal. In fact, the way this was designed, the courts were to be the weakest branch of government, and the courts were to have no power over the other 2 branches. And as you pointed out, Jefferson has written extensively about it. Alexander Hamilton, and we'll look at Federalist 78 some today. That was the article written to persuade the state of New York and others to adopt the Constitution with regard to judicial power. Alexander Hamilton said that the courts have no power over the other branches. Mm-hmm. And Patrick Henry was terrified. And when we look at the words of Montesquieu, from who we got the idea of separation of powers, he said that the most dangerous thing is justice masquerading under a robe. And that's the most dangerous fertile ground for tyranny. So, unfortunately, and we'll look at some examples today of judicial tyranny, it looks like we're just about there, but we need to recognize it. The first thing we've got to do is recognize it, to learn about it, and to face it down, and then to see what we can do to get it changed.
Yeah. Now, the judicial was supposed to have power and authority, of course. Right. But I think they were misnamed. That was the biggest mistake. Many people think because they're called the Supreme Court, they are the supreme law of the land. One of our presidential candidates, Republican presidential candidates in the last election, he made a comment about a certain decision by the Supreme Court that was counter to all of their beliefs of the way it should be. He said, but it's been decided. It's the law of the land now. No, it is not. A Supreme Court decision is not the supreme law of the land. They should have been named the High Court or Higher Court or something, but the Constitution is the Supreme Court, supreme law of the land. And when even the Supreme Court makes decisions that are contrary to the Constitution, they need to be challenged, and the authority to challenge that was given to the Congress.
Correct.
And that's why they were given the only authority to impeach. Only the Congress can impeach either the judicial or the executive or members of the Congress. They were also the only department, the only part of the government that had the authority of the purse. They could cut off funds to any court if they thought it had gone awry.
And still can.
Still can. And still should. I mean, these are, to have the authority and not use it rightly is, that's a betrayal. That's worse than not knowing what to do or something. Or, that's why it's written in the scripture. Those who know to do good but don't do it, it is sin. It is sin to them. And, these are things, though, that honestly very few in our government or in the courts, they can be on the Supreme Court. I think they can be on the Supreme Court having never read the Constitution. And it looks like that is the case with some of them on the Supreme Court. And there have been serious reversals of Supreme Court decisions.
And the best known, you mentioned this, there was a case in the early 1800s called Plessy versus Ferguson, and basically Plessy versus Ferguson established what the Supreme Court calls separate but equal. So in other words, black and white people could be equal, but it'd be okay to separate them. And then in 1954, we had the case of Brown versus Board of Education, which totally reversed Plessy versus Ferguson. Now, the Constitution did not change between those two famous cases, between Plessy versus Ferguson and then later Brown versus Board of Education. But the Supreme Court reversed itself. And it goes back to what you say. The Supreme Court is not the law, nor was it ever even given the power to impose its will on the legislature or the executive, but it reversed itself. The Constitution remains the same. So the Supreme Court has made lots of mistakes. It made a huge mistake in 1973 in a case called Roe versus Wade, which we'll talk about a little bit. Just foolish judge-making legal principles where they come up with a constitutional right to an abortion. As we'll see in a moment, even the well-noted Harvard law professor Alan Dershowitz, who favors abortion rights, which you and I don't, but he does, has conceded, and he's correct, that Roe versus Wade is poor judicial reasoning. And he has conceded that the Constitution does not give a right to an abortion, as the Supreme Court decided 7-2 in 1973. So, we have to first get ourselves up to speed. And I agree with my brother Rick here. We just encourage you to, take notes as we go through this today, and feel free to contact us, and please also share with your friends, because as Jefferson said, and we'll be quoting him today, that the price of freedom is eternal vigilance. And as Solomon said, that without a vision, the people perish. So today is an opportunity for us to be vigilant, to take care of what the Lord's given us.
Yeah. Well, keeping in mind, too, that I think a serious corruption of our courts, everything else, has been the politicizing of the judicial. And it's okay for Congress. You expect them. But judges are supposed to be blind. That's why Lady Justice has a blindfold on. She's not supposed to make decisions on they're a Republican or a Democrat or what they may feel about issues, but on the case itself. And that's why, if you have a court, let's just say right now we have kind of 5 and 4.
Right.
Easily it could go switch the other way, 5-4 to the liberal side. Then you have the country being jerked all over the place. Under one administration, it's liberal. The next one, it's conservative. And you keep getting this whiplash. And no government's going to hold together for very long like that. That's why, the Supreme Court does not have the authority to even determine what is constitutional or not. That was given to the Congress and to the people, which we'll see also Jefferson really articulates very clearly. Right. So keep in mind, regardless of what you think about the issues, it's who has the authority to resolve these issues, to determine them, that we're talking about. If we don't get back to the moorings of the Constitution, it's going to continue to get increasingly unstable from the whiplash that we're experiencing now, the kind of stuff we're experiencing now.
Exactly.
Yeah.
Well, the Constitution, of course, was a restraining device against government. It was never set up to create a lollipop factory for the welfare state.
Mm-hmm.
It was to restrain government power. And the founders distrusted government power. We'd just been through this revolution with England. The Great British Army was financed by the Bank of England. It was a miracle that our nation was born. And even the Constitution, when you think about the biblical number of 7 being the number of perfection, here's one thing I think about the Constitution. The Constitutional Convention adopted in 1787. There are 7 articles and 27 amendments. So just sort of kind of keep that in mind. It really was a document that I think was divinely inspired. It's not the Bible, but we've never seen anything about that at all. We've never seen anything like it. And the founders who set up these 3 branches of government to limit government included the judiciary as the 3rd branch. The judiciary is the Supreme Court is established under Article 3, and the power of all the federal courts are under Article 3, but it's under Article 1 where Congress can establish courts inferior to the Supreme Court. But the point of the matter is limited government. And so the court is a branch of government, but it was designed under the Constitution itself to be limited. And as we go through some of the quotes of some of the founders, including Jefferson, if you mentioned, and Adams and others, we will see exactly what the founders thought about how restricted the power of the courts should be.
Amen.
We'll be right back after this message.
A Call to Action DVD set by retired Lieutenant General Jerry Boykin. Dr. Frankenstein and World Systems by Bob Mumford. Snakes in the Lobby by Scott McCloud. I See a New America by Rick Joyner. These 4 powerful resources retail for $100. Get this Call to Action bundle today for a special price of only $55 with free shipping on domestic orders. Order by calling 1-803-548-1114 or visit store.morningstarministries.org.
The founders feared this notion of judicial tyranny. Let's start with Alexander Hamilton.
Okay.
This is taken, I believe, from Federalist 78, and we'll talk about that some more. He said the judiciary, from the nature of its functions, now listen to this, will always be the least dangerous to the political rights of the Constitution, because it will be, get this, in the least capacity to influence or injure anyone. The judiciary has no influence over the sword of the purse, no direction either of the strength or wealth of society, and can take no active resolution whatsoever. It may be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. So Jefferson basically is saying...
Hamilton.
Excuse me, this is Hamilton. Hamilton, one of the 3 men who wrote the Federalist Papers. And remember, between 1787 and 1789, the Constitution was actually finally ratified by the states in 1789 after the Constitutional Convention adopted in 1787. They write these series of essays, about 85, called the Federalist Papers, on every aspect of the Constitution. We did not have a Bill of Rights yet. The Bill of Rights didn't come along until it was written in 1789. So these men are writing to the state legislatures about various aspects of the Constitution, trying to explain, well, here's what it means. So Adams here, I'll get it in a minute. Alexander Hamilton here is writing about Article 3 to discourage and to allay fears to the members of the state legislatures who in 2 years would try to ratify this Constitution, and they did by 1789, to allay fears and put to rest any fears that the federal judiciary was going to become too powerful. So he says it'll be the least of the three branches. It won't have the power of the sword or the sword of the purse. It can't do anything on its own. It cannot, Hamilton said, influence the other branches. We've gone from there to here. You know, it's interesting. A minute ago, we were talking about Supreme Court decisions, and, you know, we don't need a divided court. We need a court with 9 justices that construe the Constitution as it was intended, as a limited, as a device to limit government. When you look, for example, at the Obamacare decision, the President Obama's own team says that this act passed by the Congress, by all the Democrats in the Congress, is not a tax. It is not a tax. So it goes up to the U.S. Supreme Court, and by a vote of 6-3, the Chief Justice of the, 5-4, Chief Justice John Roberts, who is a Bush appointee, says, well, I'm going to call it a tax to save it.
Yeah.
Now, how far have we gotten from Alexander Hamilton saying that it's the least dangerous to the political rights of the Constitution and the least capacity to annoy or injure anyone, has no influence, to where we are today? And that's with a judge appointed by a Republican who you would think would be more of a constructionist. And
if you want to take it further, how much further from this it has gotten. These lower courts.
Right.
Some justice out in Hawaii.
Right.
Appointed. Now, there are almost 300 district court judges. One of them says, I disagree with the president. I'm shutting down his program until this makes its way up to the Supreme Court, and they decide. Some judge way off in Nowheresville thinks he can thwart the president of the United States. That's how out of whack their thinking has become about their authority.
And you're talking about the travel ban that President Trump signed January 27th, 2017, just 7 days after he became president. We'll look at that in just a moment, but that's an example of district court judges going haywire on multiple fronts. Because remember, we have 3 slices to the pie, and the judicial branch is supposed to stay within its boundaries. The legislature stays within its boundaries and has its powers under Article 1, Section 8. The executive, the president, has his powers. Well, when we look at what these judges did in these travel ban cases, number one, not only did they ignore the clear law that had been adopted in the 1952 Immigration Act, the Congress gave the president the power to do what he did specifically. Not only did they ignore that, but the effect of what they were doing, they're stepping into establishing immigration policy. The federal courts do not have the constitutional authority to establish immigration policy. So they're violating this notion of separation of powers. And so we've got to understand that and call them out on it.
Yeah. Actually, even the Supreme Court doesn't have the authority to weigh in on that.
That is correct.
Yep.
Patrick Henry, who was most famous for his great speech in Richmond when he said, "Give me liberty or give me death," also was concerned and petrified about a future America where judicial tyranny reigned and where it got out of whack. And he said, "Power is the great evil with which we are contending. We have divided," as we said, power between the 3 branches of government and erected checks and balances. Remember, checks and balances being the first element of a constitutional republic. We've erected checks and balances to prevent abuse of power. However, where is the check on the power of the judiciary? If we fail to check the power of the judiciary, I predict that we will eventually live under judicial tyranny. And Patrick Henry was a man with great foresight, because what's happened, we've seen from Marbury versus Madison all the way up through judges making law in these in Roe versus Wade, all the way up, and it's the court reversing itself from Plessy versus Ferguson to Brown versus Board of Education, all the way up to the most recent Trump travel bans. We've seen a judiciary creeping in more and more, taking power that it doesn't have. 2002, and we'll talk about this in a moment, the Ninth Circuit Court of Appeals. And by the way, Congress makes these Court of Appeals. There are 12 of them, establishes every one of them, could end them tomorrow if it wanted. Ninth Circuit Court of Appeals says that the phrase "under God" in the Pledge of Allegiance is unconstitutional because it violates the Establishment Clause of the First Amendment, as if Congress has established a national religion. They just make things up, and so it's frustrating. So I think Patrick Henry, as many of the founders, had great wisdom and great foresight in foreseeing this danger at the time the Constitution was adopted. So we have to keep a watch on that. The next quote is from Montesquieu, and we've done a show already on separation of powers. Now remember, separation of powers is the first great check and balance. And under separation of powers, the founders create the first 3 articles of the Constitution. Under Article 1, we have the Congress. There are 18 specific powers Congress has, not more than 18, only 18 in Article 1, Section 8. Then we have the president. The presidency created Article 2, and the president has certain powers to sign bills into law, to veto certain bills, to serve as commander-in-chief. Then we have Article 3, and that's where the courts are set up. So Montesquieu, we got this idea from Montesquieu himself. And here's what he said, the great Frenchman from whom the founders took the idea: there is no greater tyranny than that which is perpetrated under the shield of law and in the name of justice. And that's part of the problem. Somebody puts a black robe on, and people automatically think that person's smarter or has some sort of divine wisdom that you don't have over there, and you've got a nice little suit on without a tie. I don't have a tie on either, but it's just there's a tendency to deify these judges, and unless they're following the Constitution and executing their oaths, they need to be removed from office.
Absolutely.
Going over a couple of slides over, John Marshall, and this is important. John Marshall, and Rick, you were just saying this, who was our 4th Chief Justice and our longest-serving Chief Justice, and weighing in on this, he says the judicial power, get this, does not include a right to change the Constitution.
Yeah.
Okay, but yet
to, disregard it.
Exactly. Exactly. Actually, the notion of separation of powers is that each branch is supposed to mind its own business.
Right.
And as we'll see in a moment when we look at Article 3, which established the federal courts have a scope of authority there, and that scope of authority is to hear cases and controversies. But under the Constitution, so they can hear a case under the Constitution between 2 parties. They can hear cases involving ambassadors. They can hear cases involving admiralty. But at no point, and we'll see in Article 3, at no point is any federal court giving any constitutional authority to strike down any executive order of a president or to strike down any law which is passed by the Congress, as you said a moment ago. And as we move a little bit more, we see, we're going to see Jefferson. We've got a few Jefferson quotes here, which I thought you would like.
Yeah, I've got a bunch if you run out.
Well, we'll start with these, and then we'll turn over to yours.
Yeah, you may have mine in here.
Well, probably. Jefferson, he said, the great object of my fear, and this is in 1812, he said this, is the federal judiciary. So he's afraid of it. Now, remember, this is on the other side of the case that was called Marbury versus Madison, where the Supreme Court first tried to assert its right to strike down an act of a president. He says that body, referring to the judiciary, like gravity, ever acting with noiseless foot and unalarming advance. They do these things quietly, gaining ground step by step. In other words, the courts gradually take more and more and more power. It's kind of like the story of the frog in the frying pan. You put the frog in the frying pan, and he sits there and hops around. You start turning the heat up. After a while, he didn't know what's hit him, and he's cooked, and you got fried frog leg, That's what's happening with these courts.
And in the military, it's called mission creep.
Mission creep, exactly, which is what we see with special counsel also. They advance step by step, holding what it gains. When was the last time we heard Jefferson was so wise of a court relinquishing power it's taken? Yeah. They just hold on to it. And engulfing insidiously the special governments into the jaws of which feeds them. Government will become as venal and oppressive as the government from which we separated. He is warning against the easy opportunity for judicial tyranny if we don't fight it.
And it's gradual creep.
Exactly. That's exactly right. Here's another. And this is something that's important. Here's what Jefferson said in 1820. It is very dangerous to consider judges, and you just said this a minute ago. You're right. You and Jefferson have this in common.
Yes. Even though he is considered the father of liberal politics, he was a brilliant man.
Exactly. It was very dangerous doctrine to consider judges as the ultimate arbiters of all constitutional questions. You can't turn it over to the judges. every branch, every member of the Congress, every member of the Senate, when I was a naval officer, as a lawyer, we've all taken oaths to defend the Constitution. My oath is, as a naval officer, is to defend the Constitution against all enemies, foreign and domestic. Every member of the Congress takes the same oath. So what Jefferson is saying, hey, members of Congress have the same oath to uphold the Constitution. It isn't like the judges are the only ones.
Right.
He says it's a very, very, very dangerous thing just to assume that only one branch can uphold it. And check this. Here's a letter that he wrote to Abigail Adams on judicial tyranny in 1804. Now get this. This is Thomas Jefferson. Thomas Jefferson, the guy who wrote the Declaration of Independence. Probably the most brilliant political writer and perhaps the most brilliant mind in American political history in many ways, certainly up there. He says, nothing in the Constitution has given them, meaning federal judges, the right to decide for the executive. Now, we just saw this travel ban. These federal judges took upon themselves the right to decide for the executive, even though the Constitution doesn't give them that power. A right to decide for the executive more than the executive to decide for them. In other words, it's like I pointed out. What if Donald Trump or any other president were to go to Judge James Robart out in Washington, the guy Washington State, who struck down the first Trump travel ban, and said, Judge, get off the bench. I'm going to come in here and I'm going to decide whether this evidence that is being presented before you is hearsay or not. Judge, get off the bench. I, the president, am going to come in and decide whether this person you're trying is guilty or innocent.
Yeah,
that will be an improper encroachment by the president on the judiciary. And likewise, the judiciary attempting to move in on something like federal immigration or national defense, which is reserved to the Congress and the president, is an improper encroachment. And that's exactly what Jefferson is warning about.
Yeah. And listen, again, I just throw this in because in talking to people, this is a hang-up. Well, I disagree with the president's, immigration ban. That's not the point. Whether you agree with it or disagree with it is not the point. It's who has the authority. Right. The authority of the president alone. The president alone is given the authority for foreign affairs. You couldn't have the president having his one foreign affair policies, the Congress establishing theirs separate, and then the judges having their own foreign policy. You can't do. So the Constitution gave it to the president.
Right.
Immigration comes under that, and there was another law written by Congress specifically giving this to the president, and this judge, without citing the Constitution or even the law, just said, I disagree, therefore shut it down.
That's correct.
Think about that.
Right.
How crazy that is.
You're watching part 16 of this series. You won't want to miss upcoming Prophetic Perspectives episodes where we continue examining how our Constitution has been violated and is now being attacked, and what we must do to see it restored to its place as the foundation of our republic and the supreme law of the land. This episode.
On TV, online, on the go, and on your iPad. Tune into Prophetic Perspectives with Rick Joyner, always available on MorningStarTV.com.